Welcome back to Hilaal Live. Now, Israeli President Isaac Herzog is the subject of a criminal complaint during his visit to the World Economic Forum in Davos. This is according to Swiss prosecutors, as Israel finds itself accused of committing war crimes in Gaza. A statement said the plaintiffs were seeking a criminal prosecution in parallel to a case brought before the United Nations International Court of Justice by South Africa, which has accused Israel of genocide in its offensive in Gaza. Now, Malaysia also became another country adding its name to the list. Breaking this now for us is Professor Hennie Strydom, who is an international law professor at the University of Johannesburg. Prof Strydom, good day. Thank you so much for joining us here on Hilaal Live.
Good afternoon. Good afternoon to the viewers.
Prof Strydom, let's talk, obviously, it's two separate cases, but when we deal with the ICC, it does become more of an individual case, does it, as opposed to what South Africa brought to the ICJ 2 weeks ago?
Yeah, you're quite correct. The ICJ case deals with the responsibility of states under international law, and in particular in South Africa's application, the responsibilities of Israel under the Genocide Conventions. The ICC case, as you correctly mentioned, deals with the criminal responsibility of individuals under their own statute. And that could be for war crimes, crimes against humanity, and genocide. So we have to distinguish between the two fora, and also in terms of the processes that they follow. And the case that you're talking about that comes before the Swiss authorities is about the ICC process, in which the criminal responsibility of individuals should be determined. In this specific case, the President of Israel, Mr. Herzog.
Prof Strydom, how much of this will be intertwined? Because we see, of course, countries backing South Africa, Malaysia, of course, they'll be lodging an ICJ complaint, if I stand to be corrected. So how much of this becomes intertwined with regards to the ICJ and the ICC in terms of the strength of the case against Israel?
Yeah, you're quite correct in hinting towards that intertwinement, the link between the two fora and the processes that are before. The evidence that is currently placed before the ICJ by South Africa and potentially also other countries is evidence that may be used by the ICC. Of course, the ICC is busy with its own investigation via the Office of the Chief Prosecutor. And that investigations are still ongoing for some time now. So, but it is also, the evidence before the ICJ is also to the avail of the ICC prosecutor. And the prosecutor's office may make use of that in order to substantiate its own investigations. And what it determines eventually will be a feasible case. So, and I think that's where the overlap between the two fora lies. And that is why it's so important to get a finding one way or the other by the ICJ on the application currently before it, because that will indicate also to the ICC prosecutor which parts of the evidence was used by the ICJ in coming to a ruling. And of course, it might also look beyond that to the evidence that was provided to the ICJ by South Africa and other countries.
Prof, President Herzog, right, he's got obviously that complaint by the Swiss authorities. He's not the only senior leader within Israel. There's, of course, the Prime Minister, Benjamin Netanyahu. If there's one complaint laid against President Herzog, is there a chance that another country, with regards to their prosecutors in their respective nations, can bring a very similar complaint against Netanyahu for the same accusation that, of course, the Swiss authorities have brought forward?
Yeah, the one doesn't exclude the other. Apart from that, if a country now refers a matter to the ICC, it is for the ICC to decide which individuals will fall within its sort of focus in terms of building a case against them. So the fact that there's one pending before the president doesn't exclude the possibility of also identifying other individuals within the government structure of Israel in terms of potential indictments for the other crimes or for some of the crimes provided for in the Rome Statute. I just want to raise one issue here. The evidence that comes out concerning the application to the Swiss government seems to me it is focused on potential investigations by the Swiss government. And whether the Swiss government will refer the matter in one way or another to the ICC is not clear. And whether it will, in its own courts, in the national courts, instigate proceedings. So we must understand, if that is the case, a very important issue will arise, and that's the issue of immunity in terms of prosecutions at the national level. Immunity doesn't apply for the Rome Statute, in the Rome Statute proceedings, for simple reason that it has been excluded. But it still may apply in national courts, depending on what legislation those countries have in terms of either still or recognizing immunity, international law immunity, for prosecutions of heads of state. Let me use that as one example. South Africa has adopted implementation legislation under the Rome Statute, which specifically excludes immunity of heads of state. One very good example is the al-Bashir case, where the Supreme Court of Appeal has decided in terms of our own law that the South African courts have jurisdiction in those indictments over al-Bashir, and that because of the fact that the South African law has excluded immunity as a defense for prosecutions and for surrender to the court, to the ICC.
Prof, I want to pick your brain on, obviously, going back 2 weeks ago with when the presentation was made on intent of genocide. Was there a compelling argument that was brought forward by the South African legal team? Because, of course, that's where the crux of many of these arguments were made.
Yeah, we have to distinguish, in answering that, we have to distinguish between the two phases of the ICJ application. The first one is about interim measures. So, and South Africa the court doesn't have to decide on whether Israel actually has committed genocide or violated the genocide preventions. As long as South Africa has made out a plausible case that it could be the case, and that by not providing interim measures that the civilian population will be further exposed to life-threatening developments and more harm. So it is a lower threshold than would be the case once the court deals with the merits of the case. So that is a different story. Then in that case, of course, there must be sufficient evidence for the court to come to such a finding. And at this point in time, we do not know what additional evidence will still be submitted to the court in the next few weeks or months, whatever the case might be. And we have only seen South Africa's written application and the oral arguments. But beyond that, there's other evidence that the ICJ may be to the veil of the court. So, but on the presentations made up until now, there is, I think, at least a plausible case for the interim measures phase, and for the court to come to some kind of a ruling on which measures should be provided for in order to prevent the civilian population from further harm.
Prof Strydom, one final question before we leave. South Africa, of course, set the precedents. Can there be more nations joining in that very same application? Or does there have to, of course, be separate applications? For example, one where, of course, Malaysia looking to go ahead and proceed. And we saw, of course, the Swiss authorities do the same, but from an ICC perspective. So can we see more nations going ahead and doing something similar with the ICC number 1 and of course with the ICJ number 2?
Yeah, there could be other states now at this point in time deciding to submit, additional submissions or make additional submissions to the court under the ICJ process. And any member of the Rome Statute under the ICC process can refer the situation to the court for investigation. So, and supply the kind of evidence it needs, it thinks the prosecutor may need in order to come to a finding on whether there's a good case for a prosecution. So we will have to wait and see whether states will join and which ones will join and in what way under the two different processes that are available at this point in time.
Prof Strydom, thank you so much for joining us here on Hilaal Live. Much appreciated.
Thank you, and all the best.
Thank you so much. It's Professor Hennie Strydom, the International Law Professor at the University of Johannesburg. After the break, I'll have your latest in news, finance, and sports. Do stay tuned.